Good afternoon, everybody. Nice to see you here in attendance. This is an important session, and we have the privilege of speaking to somebody who has been at the helm of the entire judicial system till just a few days back, former Chief Justice of the Supreme Court of India, Mr. Lalit, and with us also Mr. Harish Salve, who is joining us virtually. None of these gentlemen require any introduction from me specifically, so let's get to the questions. Justice Lalit, let's talk a little bit about reforms. There's been a lot of conversation recently about doing away with the collegium system, for instance. We've had the Union Law Minister talk about this. You have defended the collegium system of appointing judges strongly, saying, and I quote you, "It's perfect the way it stands today," unquote. You've also referred to the Supreme Court's judgment quashing the NJAC. But how can the collegium system be made better? There's obviously room for improvement. If it's not about losing control over appointing justices, then what other via media can we hope for?
Good afternoon, everyone. I've always maintained that collegium system on theory is near perfect. The reasons are obvious. See, at the initial entry level, when we appoint judges in the High Court, those very judges with the passage of time are picked up either to be appointed as Chief Justices in some of the High Courts or are promoted to the next higher level, which is the Supreme Court. So the entry level becomes the most crucial one. At the stage of entry, there are two streams which are available. Number one, through the lower judiciary or the district judiciary, and the advocates. The district judiciary, because of the very pyramidical structure and subordination of courts, the High Court is always in control of the district judiciary. They are aware of what kind of talent do they have. They normally, through appellate or revisional proceedings, see the judgments which come before them. So they test the ability day in and day out. Their promotions, posting, everything is done by the High Court. So they are the best lot to be aware of what kind of talent is in store in the district judiciary. So one stream is something which is completely under control, and the High Court is well aware of that. The second part, which is through the other stream, is through the advocates, that is those who practice at the bar. Naturally, the judges over a period of time have tremendous amount of idea or exposure to see the talent which practices before them. They are again well aware as to where exactly the advocate or the counsel stands, whether is he good enough in presenting a particular legal issue, is he good enough in articulating what the legal understanding or the legal conclusions ought to be drawn. So therefore the talent is again seen by the High Court, the senior judges of the High Court. The collegium at the High Court level comprises of 3 persons, Chief Justice and 2 others. Chief Justice is normally from outside. Again, it ensures element of objectivity and not any kind of partisan approach. At the same time, one of them will always be a local person. So therefore, if any essential inputs are to be given, the inputs can certainly come from such person. It is after this that certain recommendations are made. Then there are few screening levels which are still available at the state government level. When the matter reaches here, the central government, the Intelligence Bureau gives you the profile so far as if the person concerned, there is anything wrong with that persona. Lastly, The consultee judges who are here in Supreme Court and who come from that particular High Court, supposing if we are considering appointments in Bombay High Court, then those who were associated at some stage or the other in their careers as judges of the Bombay High Court or judges who were transferred to Bombay High Court, their inputs are also collected, and it is only after that that we finally, what emerges from the collegium is the acceptance of certain names. Now, in this process, see, the judiciary is always integrally connected at two levels, lower judiciary as well as the advocates who practice. And that is precisely why, rather than any outsiders, say for instance political executive, judicial organ or the persons who come from judiciary are better equipped to judge the talent. And that is why I always maintain that collegium system is better of the two.
Mr. Salve, what do you make of this argument that Justice Lalit has presented? It's really about assessing the merit, and those who have been in the system can do so best.
I've been a trenchant critic of the collegium system, and I continue to be so. And the current workings, including the public controversies which have surfaced, have established that the system is not working as it should. And I've been a critic for various reasons. The Supreme Court in 1991 was driven to construe provisions of the Constitution which had worked well for the first 3 decades plus of the Constitution, where the executive appointed judges in perfect harmony. And let's remind ourselves, some of the finest stellar members of the Indian judiciary came from that process. The Krishna Iyers, the Bhagwatis, the Tulsapurkars, the Chandrachud Senior, they all came from that system. Judges who held basic structure reins in the government came from that system. Subbarao came from that system. So we've had some stalwarts who came from that system. That system fell into disrepair when the executive started exceeding its brief and breached the protocols. In 1991, Supreme Court was driven then to holding that consultation means concurrence. Now, in no language does consultation mean concurrence, but the Supreme Court is driven to hold that. That was a fix for that moment. What followed post-91 showed that all was not well in this system. No judiciary in the world appoints itself. It's unheard of. To suggest that, and the NJAC judgment is deeply flawed in my opinion. That's my view. To say that to preserve the independence of the judiciary, it's only the judges who must appoint judges, would suggest that the American Supreme Court, would suggest that the UK Supreme Court, would suggest that the Canadian Supreme Court, would suggest that the Council d'État in France, etc., are all not independent, which is wrong. Or is it an indictment of the Indian character and a wholesale sense of disapproval or a vote of no confidence in the working of the wings of the Constitution to say judges and judges alone must appoint judges? I agree entirely with Justice Lalit that the critical input on the assessment of talents of a person can come from the judiciary. But it's quite another matter to say that the judges must be the sole arbiter of who is to be appointed. It's flawed on principle and it's flawed on policy. And thirdly, people like me have always maintained that the Supreme Court is ill-equipped to deal with the kind of controversies which arise in the appointment of judges and in the transfer of judges. And we have seen that happening. The judiciary is an institution which must only be required to speak through its judgments. And that's what they do. That's what our judges do. They deal with the most delicate cases, the most difficult cases, and they speak boldly through their judgments. And that's what they do. And that's why we say you may criticize their judgments. Don't criticize the judge, criticize his judgment if you don't like it. That's how the judicial function works. When the judges get involved in things like appointment of judges, and then there are publicly aired differences, of how people were appointed or how people were transferred, it definitely lowers the esteem of the court in the public eye. So, speaking for myself, for various, and this is a matter for a full day debate, not for 15 minutes. I have been a trenchant critic of this form of appointment. If you don't agree with the way the NGAC was constituted, maybe we could have engineered it into a better body, into a more representative body. But to say people of India, the eminent citizens of India, to say the political executive should have absolutely no say in the appointment of judges in a institutional process is something with which I don't agree.
So, Justice Lalit, Kiran Rijiju, the present law minister, has also made this point about certain degree of exceptionalism to the universal rule, so to speak. On that, I would like you to elaborate, obviously. And also, would you welcome it? Obviously, you're not in office right now. But theoretically, if the centre were to decide to file a petition against the NJAC judgment, do you think, if you were still there, would you have been open to hearing it? Would you have accepted it as a bona fide attempt at trying to revisit the entire issue?
See, very recently, a petition came up before the bench presided over by the present Chief Justice. And the Supreme Court has shown willingness to consider or revisit, at least on paper, to see whether the NJAC judgment itself requires rehaul or recall. The matter hasn't reached a stage where perhaps a larger bench is constituted and we go to the real hearing in the matter, but at least at a preliminary stage, the Chief Justice and the bench was receptive enough to say that very well we will consider the matter, and the matter is still engaging the attention of the Supreme Court. So I take it as willingness. See, any process, any thought process, or any idea or regime which has been put in place must always have a window where new thoughts, new ideas can be welcome.
Okay.
And at the same time, in case there be any course correction which is required to be made, there must be enough inclination to indulge in this course correction. And that's exactly what this particular matter which was placed before the Chief Justice's court signifies.
And on part A, the fact that the executive can't have any role, even though internationally that is the case?
See, you are right. In many jurisdictions, the judges of the Superior Court are appointed by the Parliament and the executive. Ours is a very unique idea where the judges appoint their own successors.
No, but in principle, sir, do you think a closed system such as this, which stands out like an island of exception, can be perpetuated in a democracy that demands constant transparency?
See, that's exactly why what was found was since 1991-93 onwards, till about 2015, as Mr. Salve indicated, the expression consultation appearing in Constitution was elevated to the level of concurrence. And on that basis, we had this collegium system. The collegium system was in existence. It was sought to be modified in 2015. Even that attempt was not accepted by the Supreme Court, the Constitution bench. So therefore, as of now, we are working under this system, which is the collegium system. If there be any areas, any wrinkles which need to be ironed, the court will certainly consider as and when the occasion comes up.
No, but again, I'm going to press you on this because it is an important principle. You look around you in civil society and you have systems where there is, for lack of a better word, bhagidari that goes beyond consensus. So I want to ask you this. On principle, do you believe you should have a closeted and cosseted sort of system where people are not answerable to anybody else, really, but themselves in the appointment of themselves?
See, there are always instances where one can say that you have got wonderful appointments. At the same time, there may be certain instances where one can say that these are not so good appointments. In the earlier system also, there were excellent appointments, as Mr. Salve referred to. Somebody like Krishna Iyer, who in just about 15 days, over 5 years, was brought to the Supreme Court. In today's scenario, we can't even think of a person getting to the Supreme Court in 5 years flat. But these are exceptions, certainly yes. At the same time, a system which is in vogue, which is in operation, as of now, I don't see any reason why the system should be completely displaced or discarded.
If it ain't broke, don't fix it. That's what you're saying.
No, according to me, there could be certain areas which you need to overhaul, but these are only ironing the wrinkles which are there.
Okay, so Justice Lalit, for the record, you haven't still told me what is your mind on basic principle of allowing somebody from outside, whether it's the government or the executive or what have you, from being a participant in this process. So just for the record, but yes.
See, I was a judge for 8 years. Naturally, as a judge, I have taken oath. That oath is that I will uphold the Constitution as by law established. Something which has been established in the Supreme Court for last about, say, with 3 judgments, including the one which was rendered in 2015. As a judge, I'm obliged to work under that system.
Okay, let me go across to Mr. Salve once again. Mr. Salve, we are talking about transparency. Do you believe the government too needs to be transparent? For instance, if it chooses to return a file to the Supreme Court, collegium of a judge who has been nominated or cleared for appointment, should the public also not know why the file is being returned? To take this a step further, should the IB report and the background checks, etc., made public? Should it work the other way also?
This whole process, quite frankly, and if I may not mince my words, this whole process has become pretty hopeless. I'm sorry to say so. Today, the IB gives a report. Today, you ask a person to become a judge. You ask the IB to report. The IB reports partly gossip. Do you want that to come in public domain? I don't want my personal life to come in public domain. I may not even want to be a judge. So this whole process, this whole system is incompatible with transparency. Let me tell you 3 reasons. First of all, and this is my firm belief, all judicial institutions hear cases in public, recess into their chambers and deliver judgments. What goes on inside chambers is never, ever the subject of public scrutiny. And if somebody was to ask a judge, in your meeting, when you arrived at a consensus or dissent, what did you discuss? It would be the worst form of contempt, because you're trying to undermine the judiciary. You're trying to interfere with the process by which this beautiful system works. So the judiciary's transparency is, the judiciary speaks through its judgments, and that's the transparency. What judges discuss once they go into their chambers has to be protected. Here is a function where the judges are trying to come into public domain. You want one judge to pass comments on a sitting colleague in the High Court. I don't think that's the right thing to do. 3 judges or 5 judges consider the appointment of a judge to the Supreme Court. I'm not going by the gossip you've heard of what discussions take place. I am telling you on a principle, please consider. One of the judges may say, frankly, I think his judgments are third rate. You want that to come in public? The person is a sitting Chief Justice. You are considering his name for the Supreme Court. This is a process which has to be fundamentally different. If you have this kind of a tension between the government and the judiciary, and we have seen that the government says on the one hand, you've reduced us to a post office. because the last word is with you. Many times, Jaitley, late Mr. Jaitley used to say, don't blame me, I'm the post office. I receive the file, I send it to the High Court, I get the file, I send it to them. In a situation like this, who takes responsibility? It's the court which has to today take responsibility. And in that, I don't think this system is compatible with the kind of transparency which you must have in the appointment of judges. We have to think of another way in which it is done and in which the sanctity of a person's integrity is maintained. Look at the American system. You know, if you're agreeing to be appointed a Supreme Court judge, you will have a Senate hearing, and that Senate hearing can be excoriating. All sorts of things come up in a Senate confirmation proceeding. That's one system. Will it work for us? May not work for us. We have to find some institutional mechanism by which the institution and not our court does this job. Otherwise, the judges are bringing themselves and their internal confabulations into public domain. The judges are bringing on public record what they feel about each other. The judges are bringing on public record what their personal opinion is of the merits of other sitting judges. And I don't think that's a good thing to do.
Mr. Salve, would you call upon the government today to go up in review against the NJSC government? Would you recommend that?
Well, you're assuming that the government has any interest in what I say. But if in a utopian world, I would ask the government to relook the NJSC law. The way to do it is to relook the NJSC law, see if it can be improved, and go back to Parliament and get the law reenacted. Let it be challenged in the Supreme Court. And when the earlier precedent is applied, that's the occasion to argue that that case was wrongly decided.
What are the couple of improvements, Mr. Salve, you would sort of recommend if you were to relook at the bill?
I think the constitution of the committee which was to appoint and the manner in which they will be selected needs further look. Maybe parliamentary control comes in instead of executive control. So maybe the 3 people or the 5 people who are appointed as being on the panel, not the judges, but the others, are maybe their names are put before Parliament for ratification or some such thing. So you can strengthen the institutional framework. One of the concerns judges had is you will have your pet people put there, and therefore it will be the law minister plus 3 of his friends who are on the system. Now that can be fixed. You can have a system by the Prime Minister and the leader of the opposition and 3 others will get together and appoint a person who then will represent the voice of the people on that system. You know, in England, for example, even for becoming now a King's Counsel, when we became earlier it was Queen's Counsel, there is an interview. And in that interview, there is one lay person who sits there to judge whether you're worthy of being declared what in India would call a senior counsel. So this is the fresh thinking which we must bring to bear in our system.
Let's talk a little bit about encroachment into the legislative and executive domain. That is the court's encroachment, which is again come up in the last few days as a hot topic of discussion, especially after the law minister spoke about it. And he said, and I quote, "We told the Supreme Court that the government is thinking about changing the provision of the sedition law. Despite that, the court struck down the provision of the sedition law. I was very upset about it. That is when I said everyone has a Lakshman Rekha that they should not cross," unquote. Now, just to clarify, Justice Lalit, and you know better than I, the Supreme Court has not struck down the law. It has only told the government to exercise restraint in applying this particular law and filing sedition charges, etc., about people. Nevertheless, do you believe that the Supreme Court has encroached upon the legislative and the executive domain more than it should have?
See, I have a slight difficulty because I have dealt with that matter on the judicial side. So, therefore, I can't say anything more than pure facts which are there before the court. One, way back in Kedarnath Singh, the law of sedition came up for consideration and Supreme Court said that provided you satisfy ABC component, the provision is valid, it is constitutionally acceptable. So those provisos which are ABC must be satisfied. Unfortunately, what was happening was, even in the absence of those rigors, the prosecution agencies or the investigating machinery used to come out with charge sheets which dealt with sedition as an offense. Various petitions came up before the Supreme Court. Some of the petitions then challenged the constitutional validity afresh, though it was subject matter of discussion in Kedarnath Singh. While dealing with those matters, and especially the fact that day in and day out there are certain matters where the prosecutions are launched, that is the reason why it was put to the learned counsel who was appearing for the union as to what shall be the approach hereafter. And then a statement was made that we will not go ahead with certain prosecutions. So it is in the light of those statements that the interim orders were passed by the Supreme Court. Those interim orders, the correctness of those orders again came up for consideration before certain benches. Since the basic challenge is under consideration by the Supreme Court, those interim orders are continuing. It is not as if that there is a final determination by the Supreme Court so far as the challenge to the validity is concerned. But there are interim orders. We have also said that to the extent that if you have gone purely by one of those sections and if the basic prerequisites are absent, then the prosecutions need not be launched or continued. So it is only in that light that the interim orders were passed.
I didn't mean to get into the specificities of the sedition matter, but let's explore this, because from what we see, there is seeming hypocrisy. Just recently, in fact, in the last 2 or 3 days, serious questions have been asked of the government on, for example, the appointment of the election commissioner. I think you're aware of this case. Now, is this overreach, or are there legitimate questions to be asked of the government here on an appointment process when some of those questions are not sort of interrogated properly when it comes to the appointment process of the judiciary? So here is where I suppose there is a tension and the government feels aggrieved. How do you respond to that?
First and foremost, there is no tension as such. See, any list or cause which comes up before the court, if it requires a deeper probe in a particular direction, the court is obliged and that's duty bound to go into that issue. Now, if the appointment of the election commissioner, chief election commissioner, is challenged on the ground of certain issues, then the court is obliged to put those questions to the government. Merely because those questions are put doesn't mean that there is a tension. That's a typical way of eliciting answers, and the Supreme Court is certainly entitled and duty bound to do that. So far as what exactly are the contours of the matter, I can't comment on that because it's a matter which is sub judice.
Well, the only
and to a certain extent, I was responsible for allocating that matter to the Constitution bench.
Indeed you were. And the only reason I was talking about tension is because I was judging from how the government counsel was quoted in the newspapers as well as, of course, on Times Now as having reacted. That's why. But Mr. Salve, where do you stand on this issue? The government seems to be chafing at this crossing over, so to speak.
Start with the first thing which you asked, Justice Lalit. I can say things which he couldn't say. I don't have the limitations of being a former Chief Justice.
True.
There are two wrong things which are going on here. The law minister crossed the Lakshman Rekha by what he said, in my opinion. If he thinks that the Supreme Court must hold its hand where it sees a brazenly unconstitutional law and be hostage to government's kindness to amend that law, sorry, that's wrong. Secondly, I think it's about time the Supreme Court struck down the sedition law. And let me tell you why. The sedition law was enacted by the Brits, by Lord Macaulay. We are now in 2022. Calling people to arms today, in today's context, is really a subject matter which should be governed by your anti-terrorism law. Threatening people, calling people to arms. And what the judgment Justice Lalit mentioned, said is, unless you incite people to violence, and there is a direct incitement to violence, this should not be treated as sedition. This sedition law, apart from its rampant abuse, frankly doesn't fit with the notions of free speech which we have today. It doesn't fit with the transparency which we accept today as a given, and it doesn't fit with the degree of exposure and the kind of availability of information with social media and internet which we have today. So I think it's about time we buried some of these colonial relics like the sedition law. Let Parliament come up with a nuanced law where calling people to take arms can be made a part of the anti-terror law in England. For example, it's in the public safety and the other law where such matters are dealt with. And this sedition law, which is basically to stifle speech, is now given a decent burial.
Well, we've had an interesting conversation, and as Mr. Salve and Justice Lalit have said, that this is a vast subject which can't be encapsulated in 30 minutes or 35 minutes. And obviously, viewers, we have to go into a lot of intricacies here, but it is a sampler of some of the more basic arguments that will come up in due course as these matters are heard and as more information emerges in the public domain. I hope that this discussion has been able to add some perspective to what is being considered, and that's really where we, the press, fit in. Thank you very much for watching. Thank you very much for being here.